What is it about American politicians who look to legislate away a problem while failing to address the cause? What is it about privately owned guns that scare most politicians into shaking in their own boots? And why is it that our servant legislators consistently fail to listen to we the people unless it narrowly fits into their political agendas? The Second Amendment is under attack, again. Our servant legislators are burning the candle at both ends, working to legislate stricter controls on guns, ammunition, magazines, background checks, waiting periods, private transfers, creating more gun-free zones, and more. None of which address the root cause of the problem of these psychologically unstable mass shooters, which have many Americans running scared. The answer isn't to legislate the otherwise lawful citizen into being a felon if they don't abide by these new legislative attacks on our Second Amendment. Not one of these proposed new restrictions would have prevented a single one of these mass shooters from committing their heinous crimes. Every one of these mass shooting maniacs share common traits. They're all mentally unstable. They've all been under the care of psychotropic drugs. And they all had already violated an existing law to lie, deceive, or outright steal the guns they used in the commission of their horrible acts. The history of mankind has proven countless times that we cannot legislate the unjust into morality, and that all attempts have failed at their intent and rather legislated the otherwise law-abiding into being criminals, having never committed a crime to that point. We all must learn from history as it repeats itself with regularity. With this recorded knowledge, we can address the intent of the Second Amendment to our great Constitution. 27 words which highlight the right of the people to keep and bear arms, which shall not be infringed. This is explained in great detail of over 7,000 words in Federalist Papers 28, 29, and 42. Don't take my word for it. Go read them for yourselves. It's the Supreme Court of these United States which has the ultimate responsibility and authority to judge the constitutionality of a law, and they've done that. The debate over gun control has already been had and adjudicated by the Supreme Court over more than 200 years of your servant legislators working towards turning the tables of liberty into tyranny. It started in 1803 with Mayberry versus Madison, where the Supreme Court ruled that it had the power to overturn and or control laws of Congress, with the ruling written by the great Chief Justice John Marshall, which simply said, all laws repugnant to the Constitution are null and void. In 1876, with U.S. v. Khrushchev, the court ruled the people's right to bear arms, like the right of assembly and petition, existed long before the Constitution and is not in any manner dependent upon that instrument for its existence. This ruling also upheld that all able-bodied males are members of the militia, one of three such clear rulings. In 1886, in Presser v. Illinois, the court ruled all citizens capable of bearing arms constitute the reserve militia, and the states cannot prohibit the people from keeping and bearing arms so as to disable the people from performing the militia duty of the general government. In 1895, the court ruled in U.S. v. Beard, individuals have a right to possess and use firearms for self-defense. 2 years later, in 1897, the court ruled in Robertson v. Baldwin that the right to arms is an ancient and fundamental right, a right which was inherited from our English ancestors and has existed from time immemorial. Then in 1914, in Patzone v. Pennsylvania, the Supreme Court ruled that by implication even resident aliens have the right to possess weapons such as pistols that may be supposed to be needed occasionally for self-defense. Then we moved to U.S. v. Brown in 1921, where the Supreme Court decided that a person facing a deadly attack may use lethal force in his self-defense, adding, detached reflection cannot be demanded in the presence of an uplifted knife. Next, in 1931, in Near v. Minnesota, the Supreme Court stated that the great and essential right of the people are secured against legislative as well as against executive ambition. They are secured not by laws paramount to prerogative, but by constitutions paramount to laws. Chief Justice Hughes was quoting James Madison. In U.S. v. Miller, 1939, the court ruled the militia is comprised of all able-bodied males. Ordinarily, when called, these men are expected to appear bearing arms supplied by themselves and of a kind in common military use at the time. During World War II in Murdoch v. Pennsylvania of 1943, the Supreme Court ruled the power to impose a license fee on a constitutional right amounts to prior restraint, and the power to restrict or deny the right, a tax laid specifically on the exercise of these freedoms, would be unconstitutional. Then in Reed v. Covert, 1957, the Supreme Court ruled that the United States is entirely a creature of the Constitution. Its power and authority have no other source. It can only act in accordance with the limitations imposed by the Constitution. In Bivens v. 6 Unknown Federal Agents of 1971 and Carlson v. Green in 1980, the Supreme Court ruled twice that a federal official who deprives a citizen of a right guaranteed by the U.S. Constitution may be held personally liable for damages. Again in 1980, in U.S. v. Lewis, the Supreme Court ruled that a person enjoys a fundamental right to possess arms until his first conviction for a felony offense. In U.S. v. Urquidez of 1990, the term "the people," as explicitly used in the Second Amendment and elsewhere in the Constitution and Bill of Rights, is a term chosen by the Founding Fathers to mean all individuals who make up our national community. In Hafer v. Mello in 1991, the Supreme Court ruled that a state official who, under the color of state law, deprives a citizen of a right guaranteed by the federal Constitution may be held personally liable for damages. Recently, in 2008, and again in 2010, in District of Columbia v. Heller and McDonald v. Chicago, the Supreme Court affirmed the Court of Appeals for D.C. and Chicago, which had struck down provisions of the Firearms Control Regulations of 1975 as unconstitutional, determined that handguns are arms for the purposes of the Second Amendment, found that the District of Columbia's and Chicago's Regulations Acts were unconstitutional bans, and struck down the portions of the Regulations Acts which required all firearms, including rifles and shotguns, be kept unloaded and disassembled or bound by a trigger lock. Prior to these decisions, the Firearms Control Regulations Act of 1975 also restricted residents from owning handguns except for those registered prior to 1975 in Washington, D.C. In fact, the Supreme Court of these United States has ruled 7 times since 1908 that the first 8 amendments express fundamental personal rights guaranteed by the Constitution. And if you believe that agents of the government, such as your local police, are obligated to come to your rescue, think again. In 1981, in Warren v. District of Columbia, the court stated that official police personnel and the government employing them are not generally liable to victims of criminal acts for failure to provide adequate police protection. According to the court, this rule rests upon the fundamental principle that a government and its agents are under no general duty to provide public services such as police protection to any particular individual citizen. Again, in 1989, the Supreme Court ruled that one has no constitutional right to state protection in DeShaney v. Winnebago County Department of Social Services. And the hat trick finishes in 2005 in Castle Rock v. Gonzalez, where the Supreme Court ruled that the police have no constitutional duty to protect a person from harm, even a woman who has obtained a court-issued protective order against a violent husband, making an arrest mandatory for a violation. So, my fellow Americans, the gun control debate has already been had and adjudicated by the Supreme Court of these United States in over 24 cases stemming from as far back as 1803. So then why are our servant legislators continuing to attempt to legislate away our Second Amendment rights when the Supreme Court has already ruled dozens of times in the favor of we the people? Is it truly in the interest of public safety? Is it really for the children? Of course not, and it never has been. How is a diminutive citizen expected to stop a monstrative, violent criminal intent on causing them harm? As the saying goes, God created man, Sam Colt made them equal. I submit this historical fact to you, that gun control has nothing to do with guns. Rather, it has everything to do with control. Since the late 1930s, during the lifetimes of millions of Americans, governments on nearly every continent but North America have disarmed their people and instituted a tyrannical government with a tyrannical leader, all in the name of public safety and being for the children. During the 20th century, an estimated 100 to 240 million disarmed innocent citizens were systematically murdered by their own governments after gun control was instituted. The only thing which keeps a government from assuming too much authority is an armed and vigilant citizenry. And the universal instance which prevents the criminally inclined from victimizing you is knowing that you are, or are likely, armed. And the one thing which would have stopped each and every mass shooter from inflicting their multiple casualties and destroying so many families is an armed citizen, armed, trained, and prepared to use a gun to stop these psychotic madmen at the onset of their attack. Our servant legislators say that if a gun control saves even one life, then it's worth it. I say look at history, and history will show that the plethora of armed citizens have saved far more lives than the unarmed. Don't buy into the drivel of a safer society as posed by our servant legislators, as history has proved that theory wrong in every single instant throughout human history. Don't play into the agenda of the controlled media to see an emasculated society disarmed and standing ripe for attack by every violent criminal to victimize at will. Instead, demand that our servant legislators stop this nonsensical deliberation of gun control and infringement of our rights. Demand that these acts of sedition stop immediately, as the Supreme Court has already ruled on the topic and has ruled in the favor of we the people for over 200 years. Refrain from buying into the ideology of the feeling of today's society and support the rights enjoyed by all Americans. Even if you choose not to exercise your personal rights to keep and bear arms, you must remain vigilant in supporting those rights of your fellow citizens who do, because they will support the rights you do choose to exercise when those rights come under attack. I submit this to you on behalf of the founding defenders. I am Kubler.